Hafaday, I'm Ruel Drulan, and welcome to the second installment of the 27th Annual GSAT Conference. Today, we begin our program with a message from Attorney Daniel Summerflecht, the Executive Director of Guam Legal Services Corporation Disability Law Center.
Hafaday, my name is Daniel Summerfleck, and I am the Executive Director of Guam Legal Services Corporation Disability Law Center. I am very pleased to welcome you to the 27th Annual GSAT Conference. As the pandemic has brought us many challenges in both our personal and professional lives, it is important that we remain committed to providing effective and inclusive services to all. This year's conference theme is creating more opportunities in a changing world, and it is my hope that this conference will bring you opportunities to expand your access to technology in meeting your individual needs, the needs of our consumers, the community, and the people who we serve through digital platforms. I'd like to take this opportunity to acknowledge the work of our Tri-Agency on Developmental Disabilities Partners, the GDDC, and the UOG Cedders for making this conference possible. And to all of you, thank you for being here with us today. Thank you again.
All people deserve basic human rights. That's why Congress created a system of protection and advocacy agencies, also known as P&As, to protect and advocate for the rights of people with disabilities, because in the past, they have not been treated equally. For most of the 20th century, the phrase out of sight, out of mind was more than just a popular saying. It was the means for dealing with an unwanted segment of the population. People with disabilities were either segregated from society, locked away in institutions, or remained isolated at home with absolutely no services, not even an education. They were abused, neglected, and forgotten. Then, in 1973, ABC News cameras exposed the filthy living conditions and poor treatment inside Staten Island's Willowbrook School, which housed people with developmental and intellectual disabilities. It shocked the nation.
The doctor had warned me that it would be bad. It was horrible.
Finally, in 1975, Congress acted. They mandated that every U.S. state and territory have an official protection and advocacy agency. P&As go by many names, but their mission is the same: to protect and advocate for the rights of people with disabilities. Together, the P&As form the National Disability Rights Network, taking on issues affecting people with all kinds of disabilities. No other organizations have the sweeping access authority that P&As have. They go anywhere services for people with disabilities are provided, from schools to hospitals to prisons and jails, to monitor conditions and listen to concerns. They make sure people with disabilities are treated equally, with dignity and respect, and never have to face the same kind of mistreatment they saw at Willowbrook. P&As ask the public for input on which issues to take on in their communities. P&As can fight against abuse and neglect in residential services, to end exploitation at work, for fair treatment in the criminal justice system, for equal access to public education and voting, for accessible communities and services and assistive technologies, and countless other issues. That's the protection and advocacy system. Click here to find the P&A for your state or territory, and subscribe for more videos from the P&A network at Rooted in Rights.
Speaking on the issue of reasonable assistive technology accommodations in the workplace, we welcome back Attorney Daniel Summerfleck.
Hello, my name is Daniel Summerfleck, and I am the Director of Guam Legal Services Disability Law Center. It's my pleasure to do a presentation to you all today about disabilities in the workplace. Before going into that, I'd like to talk just briefly about Guam Legal Services Disability Law Center. Guam Legal Services is not a government organization. We are a private, nonprofit corporation established in 1979. We opened our doors in 1981, and although some of you may have heard 2 years ago about our 40th anniversary, I look at this year as our 40th anniversary because this is 40 years from when we actually started providing services. As far as being a protection and advocacy program, in 1999, Guam Legal Services Disability Law Center was designated as the Protection and Advocacy Program for Guam by then Governor Cedders. We are, like I've said, we're not part of the government of Guam or the federal government. We do have powers and authorities granted to us by Congress as a protection and advocacy program. We receive our funding through 10 federal funded programs and our court-appointed services. The protection and advocacy programs exist throughout the nation. The mission of Guam Legal Services is to promote, educate, and advocate for equal rights and access to justice for underserviced communities. Guam Legal Services services individuals with disabilities, victims of violence and sexual assault, and in numerous court-appointed cases as what's called a guardian ad litem. When looking at disability in the workplace, the key legislation that was passed to provide access to persons with disabilities to all aspects of life was the passage of the Americans with Disabilities Act in 1990. That act requires that public and private entities provide access to facilities, organizations not to discriminate against people with disabilities. The Americans with Disabilities Act prevents discrimination against individuals with disabilities in employment, government activities, public accommodation and commercial facilities, communication, and has a section of other miscellaneous provisions. One of the major changes that occurred in the Americans with Disabilities Act since 1990 was in 2008. In 2008, the Americans with Disabilities Act was amended to provide a broader definition of what a disability is. What happened was from 1990 to 2008, there was numerous litigations and numerous court decisions determining who was a person with a disability and who wasn't a person with a disability. So Congress came forward and amended the Americans with Disabilities Act to define disabilities as shall be construed in favor of broad coverage and should not require extensive analysis. Disabilities in the past were very narrowly defined, and by eliminating that narrow definition, it provided much greater coverage for persons with disabilities to access their rights under the ADA. A person has, under the ADA, a person has a disability if there's a physical and mental impairment that substantially limits one or more major life activities of such individuals, has a record of such an impairment, and is regarded as having such an impairment. The question may come, what is a major life activity? In looking at major life activities, it's fairly basic. Caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating. It's not an inclusive list. Anything that impairs in major life activities of an individual can be considered as a disability. Under the ADA, there are enforcement provisions. There's the employment provisions under EEOC. There's the Department of Transportation. There's the Federal Communications Commission. And of course, there's the Department of Justice Civil Rights Division. All of these areas are federal government agencies that are focused on assisting persons with disabilities having access to employment, public benefits, and other things. if a person falls within the definition of a disability, it does not mean that they automatically are a victim of unlawful discrimination. An individual with this disability still needs to show that he or she was subject to an act prohibited under the Act because of actual or perceived physical or mental impairments. So just being a person with a disability does not mean automatically that you've been subject to unlawful discrimination. There has to be some action that interferes or prohibits the individual because of their physical or mental impairment. What the ADA requires under employment is that no covered employer shall discriminate against a qualified individual based upon their disability. What is the discrimination that is included in the Act? Failing to provide reasonable accommodations to a known physical or mental limitation of an individual or employee, unless the employer can show that there's an undue hardship on the operation of the employer's business. Undue hardship factors that are considered, it's not just the employer saying it's an undue hardship. There are factors that are considered, and these include the nature and the cost of the accommodation, looking at the employer as a whole, considering other things such as tax credit, revenues of the employer, the overall financial resources of the facility, the effect, the expense and resources, and the number of persons employed there, the overall financial resources of the employer, the overall size with respect to the number of employees, and the type and location of its facilities. So what may be considered an undue hardship for a small employer may not be considered an undue hardship for a larger employer who has numerous employees and larger facilities. And then, of course, the impact of the accommodation on the facility. In order to be an employer covered under ADA, the employer has to have 15 or more employees working at least 120 calendar weeks a year, or an employment agency, or a labor organization. Those are employers and agencies that are covered under Title I of ADA, which deals with employment discrimination. So again, there must be more than 15 employees, 15 or more, or it's a labor agent, an employment agency, or a labor organization. Now, in order to be able to qualify for a job, you need to be able to perform the essential functions of a job. For example, if an individual with a disability applies to become a firefighter, there are essential functions of becoming a firefighter, and one of those may be being able to lift and transport a 100-pound item. That could be considered a fundamental function or an essential function of a firefighter job. Employers are not required to modify the essential functions of a position. ADA statute provides that employers' written job descriptions before interviewing is relevant evidence. So, for example, if you went to an employer and their essential job functions didn't include lifting a 100-pound object, and all of a sudden after your interview they say, well, part of our essential functions is being able to lift a 100-pound object, that would not be considered an essential function, and that would also be considered a discriminatory act. So in order to be a qualified individual, what that means is a person who can perform the essential functions of a job for which he or she has applied for, with or without reasonable accommodation, meets the object requirements of education and training. For example, you can't say, I want to do this job, but I don't have the education to do the job or meet the educational requirements, but I should have it because I'm a person with a disability. That doesn't work. You need to be able to perform the essential functions, and you have to have the required education and training for the position you're applying for. So the question might be asked, what are reasonable accommodations if I already have to meet the essential functions of the job and I have to have the education and training to perform the job? What reasonable accommodations provide is the ability for you to perform the job with your disabling conditions. So reasonable accommodations is a change or adjustment to the job or the environment to allow the person to participate in the application process, perform the essential functions of the job, and enjoy the benefits and privileges of employment. So a reasonable accommodation, when you're looking at it, you're looking at a couple of factors. The first factor is that you have the ability to apply for the job. The second factor is that you're provided accommodation to perform the essential functions that you're already capable to perform. So examples of reasonable accommodation could be considered job restructuring, modifying of work schedule, reassignment to a different job, providing qualified readers and interpreters, acquiring or modifying work equipment and devices, appropriate adjustments or modifications of examinations, training materials, or policies. Those have been considered reasonable accommodations. A reasonable accommodation must be provided unless it results in undue hardship to the employer, it possesses a direct threat to the health and safety of the employee or others, and it does not result in a fundamental alteration of the position. Reasonable accommodations need not be the best accommodations, the most expensive accommodations, or even the most ideal. It only needs to be effective. Accommodation should assist in helping the person perform the job function. Employers do not have to provide adjustment or modifications that are primarily for personal benefit of the employee. In other words, the employer's accommodations are to allow you to perform the work. They're not to allow you to receive additional personal benefits. They're not required to provide personal items needed to accomplish the daily activities, both on and off the job. So you couldn't go to your employer and say, I need a reasonable accommodation, my wheelchair is not working right, I need you to buy me one. That would not be considered a reasonable accommodation. That would be considered a personal item.
And now for a short break.
Sa kabahatin kaya, apopuseni tuvicin silay fos. Terin tuvicin silay fos, apopuseni pungun selingan semirit. Inamo ika eso kon watte pungun selingan awa semirit, ngaterin an awa semirit tuvicin silay fos mi fokun watte. Kian ana power akawa sakon apet me alilisin tuvicin silay fos, si pamutir cheki ika mi pung selingan awa semirit. Ren porau sechin awa programin check-in selingan semirit, kosamochan kakurino chay nampa. Fisu ulangat limu, ruanu ono.
Back with Attorney Daniel Summerflecht on disability law in the workplace.
Reasonable accommodations are also more limited than that. Employer does not have to excuse a violation of uniformly applied conduct rules that is legitimate and non-discriminatory. That would be similar to if you become violent at the workplace, That is not an area that needs to be accommodated. They do not have to accommodate by eliminating essential job functions. To say that I want to be a fighter, but I want you to eliminate the requirement that I be able to move a 100-pound object is not considered a reasonable accommodation. It's considered an elimination of an essential job function. Employers are not required to create new positions or move someone from the position they're in to accommodate another employee. They're also not required to lower legitimate quality and quantity requirements. You still need to be as productive in your job with the accommodations as a non-disabled employee. Employers also do not have to provide an accommodation that would cause undue hardship on or a direct threat to the business. This is again referring to tolerating violence or abusive behavior. You are required, even with accommodations, to follow the codes of conduct that are required at the business. In order to obtain a reasonable accommodation, it is not something where you can walk into your employer and say, I would like a reasonable accommodation. Here is my list of what accommodations I would like you to provide me. It is an interactive process where the employer and the employee work together in good faith to develop accommodations that are both reasonable to the employer and accommodate the employee. An employer's failure to engage in the interactive process is not in and of itself against the law, but it does have relevancy when it results in a failure to identify a reasonable accommodation that does exist. Now, one of the key aspects of reasonable accommodations in persons with disabilities, it is not the employer's responsibility to ask the employee, how can I accommodate you? It is 100% the responsibility of the employee to come forward, to identify for the employer the disabling condition, and usually with the recommendations of a medical professional as to what accommodations the employee may need to be able to perform the functions. So again, it is the responsibility of the employee to request reasonable accommodations. It should always be in writing. It should always have a reason for the request. It should always put forward the requested accommodations, and I would highly recommend including a note from a medical professional as to what the accommodations need to be. After the request, the employer should initiate the interactive process, including the employee, her supervisor, and any other relevant people, which may include a doctor, it may include human resources, or it may include an assistive technology specialist. Employers are allowed to request a more in-depth information, if needed, relating to the nature, the severity, and the duration of the impairment, the activities that are limited, and how the impairment relates to the accommodation, and how the reasonable accommodation will help the person do the job. This is not something that can be asked in the interview process, but it is something that you may be asked once you request reasonable accommodations at the workplace. Again, employers are not required to provide any accommodation that an employee requests. A lot of the litigation that has gone on in the court system regarding ADA and accommodations is employers coming forward and saying, this is an undue hardship. And again, what the courts are going to look at is the significant difficulty or expense placed upon the employer, the employment agency, or the labor organization. It can also look at the financial difficulties, unduly costly, excessive, substantially disruptive, or you will hear this quite a few times when addressing issues under the ADA. It's a fundamental alteration of the nature of the business. Those are what are considered undue hardships. Another defense that comes forward is a direct threat, a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodations. So if behavior is such that it's a risk to the safety of others or to the employee seeking the accommodation, it may be considered not something accommodable. But employers must investigate whether a direct threat can be eliminated or reduced by a reasonable accommodation. So in the workplace, I just want to do a quick recap. In the workplace, if you already have the job and you are seeking an accommodation, it is not automatic. For example, in a number of GovGuam agencies, each year you need to renew your request for accommodations. It falls upon the employee to make the request for the accommodation. And then, as I've mentioned, it's an interactive process where there may be negotiation as to what is a reasonable accommodation. In the aspect of obtaining the employment, in the aspect of applying for a job, persons with disabilities are not required to mention that they have a disability unless or until they need a reasonable accommodation. So inside of the interview process, there is now not any requirement to mention that you have a disability, unless you need some accommodation during the application phase. Then the individual will need to mention the disability to request the accommodation for the application process. A person is never required to disclose a disability generally. So only if you seek accommodation are you required to disclose your disability to employers. Reasonable accommodations at the applicant interview phase include providing a person to read or interpret the application materials, demonstrating what the job requires, modifying tests, training materials, testing time, or policy manuals, replacing a written test with a more extensive interview which allows the individual to demonstrate their knowledge, skills at the worksite, and also allowing a support person during the interviews. Those are accommodations that have already been proven in the courts individuals can seek in the interview process. But you cannot seek them unless you disclose that you are a person with a disability. An employer cannot ask a question that is likely to elicit information about a disability, such as, what physical disabilities do you have? If an employer asks that question in the interview process, they are discriminating in their hiring process. Have you ever been treated for a mental disorder is another discriminatory question. Have you missed any work for illness, and for how many days? Have you ever undergone treatment for these diseases or conditions? For what have you ever been hospitalized for? These are questions that either are asking you regarding your disability or intended to elicit information about your disability. Those questions are not allowed to be asked during the interview process. Employer may ask questions about an employee's ability to perform the essential functions of their job. So again, coming back to the firefighter example, are you capable of moving a 100-pound object? If it's an essential function of the job, the employer is able to ask questions about your ability to perform them. State the physical requirements of the job and ask an employee if they can satisfy these with or without reasonable accommodations. Ask someone to describe or demonstrate how they would do the job. Again, these questions are focusing on, is the employee able to perform the essential functions of the job, which is a requirement under ADA. In preparing for the interview, applications and procedures should follow the ADA. Employment offices and buildings where the interview takes place should be ADA accessible. Upon request, make appropriate and reasonable accommodations to allow the applicant to present themselves at their best. Do not have a social worker or a rehab counselor present unless required.
And now for a short break.
언어는 다양한 유형이 학습을 위한 기초입니다. 듣는 능력에 손실이 있다면 언어 발달에 영향을 미칩니다. 가벼운 청력 손실조차도 아동의 언어 발달에 심각한 영향을 줄 수 있습니다. 청력 손실이 조기 발견은 언어 개발을 촉진하기 위한 적절한 개입 서비스를 제공하는 데 중요합니다. 신생아 청력 검사 프로그램에 관한 더 자세한 정보는 735-2466번으로 문의하십시오.
Back with attorney Daniel Summerflecht on disability law in the workplace.
In conducting the interview, all questions must be focused strictly on job-related issues, with no discussion on accommodations unless there is a known disability. Employers should not speculate as to how the applicant would do their work if they have a specific disability. If their disability is known and it may affect an essential job function, the interviewer may ask the applicant how they would do their work. Again, looking at not the disability, but the essential functions of the job. Now, under ADA and under law, there is what's called hostile work environment. Employers are required to maintain a hassle-free workplace for all employees. Disability awareness may be necessary to address attitudes of managers and other employees. Employees are responsible for the actions taken in their workplace by their employees. There was a case that occurred a number of years back in a trucking facility. And one of the gentlemen that worked at the trucking facility was what is called morbidly obese. He weighed over 400 pounds. He was a very large gentleman. Because of that, other employees would make fun of them. At one event, while they were in the lunchroom, one of the employees put on this gentleman's shirt, which was excessively large on him, and danced around on the table and made comments about how he was wearing a tent and da-da-da, much to the chagrin of the gentleman who was morbidly obese. What ended up happening in that case is the gentleman who was morbidly obese asserted that he was not only exposed to a hostile work environment, but he was also treated poorly under the ADA and discriminated against. The end result of that case was pretty much a big chunk of that workforce ended up getting fired. The entire workforce had to be retrained, and the individual that was discriminated against was allowed to seek other employment without loss of income until the alternate employment equaled that he would have made at the trucking company. So creating these environments are negative not only by the individual that's doing it, but it also can affect management, and it can also affect the employer. Making sure that a workforce is maintained as a hassle-free environment is a key issue for all employers. Hostile work environment generally requires a number of issues before you can bring a disability harassment claim. First of all, the individual must be a person with a disability. The harassment must be based on the disability. The harassment must be unwelcome, and it must be sufficiently severe or pervasive enough to negatively impact the terms, condition, or privileges of employment. The employer knew or should have known of the actions and failed to take actions. So coming back to the trucking situation, because the individual was morbidly obese, he was defined as qualified as an individual with a disability. He was being directly harassed as a result of his disability. Clearly, the harassment was very unwelcome, and it was so severe or pervasive that the employee no longer felt comfortable even going to the work site anymore. And because this had been an ongoing issue, management and the employer were aware and failed to take corrective action. So everyone involved in that case had liability. So in looking at a hostile work environment, employers are required to provide and maintain a hassle-free workplace. Employers, if there's any indication of a negative work environment, disability awareness must be provided to the employees to address the attitude of management and the other employees. And employers are responsible for the actions taken in the workplace by their employees. Adjusting and modifying the work conditions. This is another area where there is tremendous amounts of litigation. Reasonable accommodations may require restructuring the job, making modifications to the schedule, policies, and so on. Reasonable accommodations can have switch to non-essential functions. So for example, if you're required to sweep the stairs and you have a prosthetic leg, you could be switched to cleaning the lower kitchen, changing the manner of the tasks, modifying the job requirements. No need to lower the quality or quantity standards. And if there's a position vacant, that could be considered an accommodation. So modification of the work schedule is a generally allowable modification or accommodation. And that can include allowing schedule flexibility, arrival or departure times, sensitive to lights, more frequent breaks, allowing time off or part-time in certain circumstances, changing policies that requiring scheduling vacations in advance, particularly where it's for medical issues, providing leave unless it's an undue hardship. It also includes equipment and devices. These can be considered reasonable accommodations. This is one of the areas where there's a lot of back and forth because, again, it's not the best, it's not what the employee desires, it's what's reasonable given the situation. So while everyone may want to have the fastest computer that just came out so that they're more efficient and more effective, that can't be considered a reasonable modification just to have the fastest equipment. Just something so that allows the employee to continue with employment. So it might be acquiring or modifying equipment and devices. It might be tape recording instructions, a larger button telephone, all-day accessible video to demonstrate tasks, use of colored markers, simplified machinery instructions using diagrams, or modification of software and hardware. For example, for an individual with dyslexia, it may be considered a reasonable accommodation to provide a program that they can speak into rather than to do the written word that then translates that to paper. Learning and doing the job. Those are part of reasonable accommodations. To provide auxiliary aids or services, amplifiers, hearing aid compatible phones, interpreters, note-taking, breaking job tasks into sequential steps. In other words, breaking down the job function. Don't just say, go turn on the machine and it'll run itself. Break it down. First you turn on switch number 1, then you turn on switch number 2, then you turn on switch number 3, as well as providing a diagram as to which switches to turn. Those could all be considered reasonable accommodations. Using visual pictures, charts, colors, demonstrations, and even verbal prompting are considered reasonable accommodations. Learning and doing the job. In order to learn the job, oftentimes it may require, and it's considered a reasonable accommodation, to allow a job coach, to have internal supports, modify certain policies allowing non-employees in restricted areas, modifying training. In other words, change the way you train, provide braille materials. Employers cannot refuse because of the ADA Title I. Trainers cannot be refused. So if you have a job coach or a trainer, they can't be refused under the ADA. Modified supervision is considered an accommodation. Review tasks to be completed on a daily basis. Provide more frequent feedback. Assign a new supervisor is not a reasonable accommodation. You cannot say, my reasonable accommodation is I don't want to work with so-and-so. But you can require additional feedback, review of tasks. Those are accommodations that can be requested. You cannot, it is never considered a reasonable accommodation to get a new supervisor. Other modifications in policies include allowing service animals, allowing to bring someone for support during meetings, modifying emergency evacuation procedures, modifying conduct rules not job related. You know, those can be done, but again, modifying conduct rules, you're moving into a very slippery slope.
And now for a short break.
I just so love doing this, talking to her.
Technology helps people with hearing and vision loss connect in many ways with widescreen monitors and braille note takers.
I can actually see you when you get to the end a block, make a right.
Excellent.
laptops,
We're moving to Florida.
Okay.
screen magnification software,
Oh, what a great picture.
That's nice. When did you see that?
I saw them October 18th.
braille displays,
Veronica.
Baseball clinic has been canceled.
screen reading software
Oh, man.
Can I come by to say hello?
with tablets
Bite for dinner.
Oh, that sounds like a plan.
and smartphones. Desktop computers, specialized keyboards,
Do you want to go to lunch today?
and more.
That's nice.
I Can Connect.
Kids.
I Can Connect provides equipment and training to help people with combined hearing and vision loss connect with the world. Find your state program at icanconnect.org or call 800-825-4595 or TTY 888-320-2656.
Back with attorney Daniel Summerflecht on disability law in the workplace.
One of the bigger areas that has recently come up has been service animals. And service animals are defined by the Department of Justice Civil Rights Divisions as dogs that are individually trained to do work or perform tasks for people with disabilities. There's a major difference between a service animal and a comfort animal. Service animals are specifically trained to do work or perform tasks for people with disabilities. Generally, they are certified, trained, such as a seeing eye dog. They are not just dogs off the street. It is restricted to dogs. New laws and guidance are pending as to dog breeds and other services they provide. Other animals may be considered comfort animals, like cats, miniature horses. Same thing. They are not considered service animals unless they are trained for a specific task to assist the person with the disability. And dogs and cats have not been shown to be able to do those sort of tasks. Dogs, yes. Miniature horses and cats, no. There is a lot of people that believe that their comfort animal is a service animal and therefore they are allowed to get accommodations. That's not accurate. Service animals, again, are specifically trained. Generally, they're certified. Service animals must be allowed in government offices, businesses, nonprofits that service the public, in areas that the public is allowed, and in work areas of the employees. Comfort animals are not at all allowed. It's important to know that these are requirements for service animals, both for employees and customers. But again, service animals are not the little tiny dogs that provide comfort to people. They are working dogs, and they must be under control and harness, unless such will interfere with their tasks. If they are loose, they must be able to respond to a voice or a signal. They can be required to leave if they are not in control and are not housebroken. Limited inquiries can be done with regard to service animal, and the first of which is the dog a service animal required because of a disability? What work or tasks has the dog been trained to perform? It's not asking about the individual's disability. It's asking about the service animal to show that they are actually a service animal and not a comfort animal, because if the dog has not been trained to perform any specific tasks, they are not a service animal. Cannot require documentation or ask for a demonstration of how the task is performed. So employers can ask, but they can't require documentation. The other thing about service animals is they're not required to be cared for by anyone but the employee. Staff are not required to provide care or food for service animals. That is 100% falls on the responsibility of the individual using the service animal. Under the Division of Civil Rights, as to service animals, it has been provided in the ADA. I want to do a brief recap before I conclude, because there are a number of issues that I've discussed that are recurring issues. So I want to go through a process with you very quickly while I still have time. The first step in the process is applying for work. As I've stated, employers are not allowed to ask about any disabling conditions during the interview process. Employers are not allowed to ask of any disabling conditions even in the application process. Employers are allowed to ask about the ability to perform essential job functions. So in the process of obtaining employment, if you seek accommodation in the application process, then you do need to disclose your disabling condition. If you do not seek accommodation in the application process, then you are not required to disclose. In the interview process, if you seek accommodation in the interview process, such as having someone else sit in on the interview, then you are going to be required to disclose that you have a disability. But you are not required to disclose your disability just to access the interview process. Employers are required to have ADA accessible employment sites. Upon obtaining employment and you're employed by the employer, it is not the employer's responsibility to ask you, do you need accommodation? It falls 100% on the employee to make a request for accommodation, to provide information about what accommodation they are requesting, and perhaps to provide support from a medical professional as to why that accommodation is needed. It is not an automatic process, and employers are not required to provide you the accommodation you request. They are required to provide reasonable accommodations, and that should be, as I've mentioned, an interactive process between the employer and the employee as to what is considered reasonable. Certain times, employers will not be required to provide reasonable accommodations if it becomes an undue hardship either on the business itself or a financial undue hardship. And finally, when looking at service animals, there is a major difference between a service animal and a comfort animal. Service animals have specific training to work with issues that affect an individual with disability. Comfort animals are not included in the ADA and are not treated the same as service animals. Service animals have absolute access to any government-operated or public facility, even a private facility. Comfort animals do not. I would thank you very much for your time and attention during my presentation, and I hope that this has been of some help to you all in moving toward full integration. Thank you very much.
Share your feedback on disability law in the workplace. Dr. Gretchen Colade has spent her career as a special education teacher, teaching students with severe disabilities. Much of her research interest has been around increasing capacity for educators in meeting the needs of children and their families, collaborative team processes, and augmentative and alternative communication devices and systems to support communication of young children with complex communication needs in early childhood inclusive settings. Speaking today on choosing assistive technology for students with disabilities, here is Dr. Colade.
My name is Dr. Gretchen Colade, and it is my pleasure to invite you and inform you about what you will learn during these several day sessions about assistive technology. The title for the session, the overall title, is Assistive Tech Assessment in Education, Assessment Technology for All Students with a Disability. So first, let me introduce myself. I am a teacher. Right now on the screen, you see first my favorite quote. And my favorite quote is that you teach who you are. And it's from the book, The Courage to Teach by Parker Palmer. I highly suggest you look into borrowing it or finding it to read. You will spend a lot of reflective time thinking about the courage to teach. In the picture that I have permission to share are some of my students. I currently am a teaching assistant professor at Oklahoma State University in Stillwater, Oklahoma. I prepare early childhood education teachers to meet the needs of all children in their classrooms. And as we know, in early childhood education settings, we hope and we plan for them to be inclusive settings so that children both with and without disabilities, those with diagnosed disabilities, those who have a disability but have yet to be diagnosed, are welcomed into a setting in their classrooms where they belong, where they become part of the community, and they use assistive technology to do that. So here are some of my students. We were presenting research in Biloxi, Mississippi several years ago. Obviously, you can tell by the lack of masks that it was during pre-COVID times. Let me tell you a little bit more about myself. I have a bachelor's degree in special education from Old Dominion University. And I'll date myself. It was so long ago that it was a bachelor's in special education without any content area. Very scary degree to give to a 22-year-old. However, I made the best of it. I then earned my master's degree in early childhood education from Boston University. And then I've been a teacher all along. And while teaching in public schools, I earned my national board certification from the National Board for Professional Teaching Standards, and I earned that in exceptional needs. At the time that I earned my national boards, it was in 2001, I earned it in working with students with mild to moderate disabilities, and then in 2011, I renewed it. And actually, right now, I am currently going through renewal again. I then earned my PhD at Oklahoma State University in special education. My dissertation primarily focused on how teams of stakeholders supported young children with complex communication needs, which of course involved assistive technology. And so all through my career, I worked with assistive technology and implemented assistive technology in my classroom, and then turned it into my dissertation. Another part of who I am is personally, I am the sibling to Michael. This is a picture of my brother. Michael is 61 years old. He will tell you he is my big brother. Michael has multiple disabilities. And as his younger sibling, I don't know a day of my life without having Michael in it. Michael uses assistive technology throughout his life now as he is in a group home, living as independently as he can with supervision in the Washington, D.C. area. And I am his guardian now that we've lost our parents. And so I bring two hats and two perspectives to this training. I not only bring the hat of professional, but I also bring the hat of personal and as a family member. And this is a picture of my class. Again, I have permission to share it. This was the last semester that I taught my class. We actually walked the Oklahoma City Bombing Memorial Marathon. It was in April that year, and it was 44 degrees and raining sideways. And all my students showed up to walk the marathon. You actually walked 25 miles prior. We started in January and finished right before, and then you walk a 1.2 that day. So that's who I am, and that's who the perspectives I will bring to the trainings. So, all right, let's talk about what you're going to learn in the trainings. Again, it is assistive technology for all students with a disability. And what we will do is we will start with consideration. And please, what you need to know about why we're going to start with consideration is that consideration is step one in what is called the quality indicators for assistive technology. We, of course, in special education have tons of acronyms, and this is one of them. The QUIET actually consists of 8 different indicators. The very first one is consideration, which is why it's so important for us to start with that in our training. Now I'll go through the list real quickly. Along with consideration, there's assessment of assistive tech needs, there's assistive tech in the IEP, there's assistive tech implementation. There's then evaluation of effectiveness in assistive technology in transition, and realize that transition can be between programs, or it can also be at the end of public school and into adulthood. The 7th step of the QUIET is the administrative support for assistive technology. We know that if we don't have admin support, that it is an uphill battle then of not only informing them of what we know, but also then gaining their support for our requests. And then finally, the 8th step of the QUIET is assistive technology professional development. So really, in this session, you're going to meet several of those steps, and certainly, really, we're kind of starting with step 8, aren't we, with professional development. So we're going to start with consideration. And the first thing is you need to be able to, and you will be able to, describe consideration of assistive tech for all students with disabilities. What we will do in our sessions together is we will realize that, number one, all students, regardless of what their disability is, what their abilities are, and what their needs are, they must be able to communicate and interact at the same level as their peers without disabilities. That puts a different lens on assistive technology, that what we need to do is we need to consider, are they communicating the way their peers are? Are they completing work the way their peers are? Are they able to interact with peers, with us, with the cafeteria staff, the way their peers are? And if the answer is no, then that's where we need to absolutely positively know the steps within consideration to be able to make a decision on what we should do next. Again, we need to compare them to same age peers, so that way we can say, this is what the typical 15-year-old does in class. This is what the typical 4-year-old does in preschool. And that's what we look at. The second step that you will understand from our training is the difference between assistive tech services and assistive tech devices. Please understand that the Guam system for AT offers both. What they are required to do, what all AT organizations are required to do, is to, number one, provide you with information about devices, and to provide you with loans of those devices, so that way you can, what we call in the business, try before you buy. And then they offer assistive tech services. And one of the services is professional development, just like today, and just like what you will encounter over the next several workshops that I provide for you. And then finally, under consideration, we're going to review the different categories of assistive technology. Within the Guam system for AT, they have the following categories. The first is computers and related to computers. Oh my gosh, we're going to have so much fun examining all of the different devices that are available through the Guam system for AT. Computer devices can be anything to help us with accessing computers. What we need to understand is way back in 1991, the IBM company put out a manual, and in it, it said that technology for people without disabilities makes life easier. And it does, doesn't it? Oh my gosh, what would we do without our phones? I had to travel to several different student teacher schools yesterday that I hadn't been to yet because of COVID. And I would have been lost without my Google Maps. And so we need to understand that it makes our lives easier. But what the IBM manual continued to say, the next sentence was, technology for people with disabilities makes life possible. And so the computer assistive technology devices are phenomenal. That you name the keyboard need, and there is a keyboard to meet that person's need. You name the mouse. I know I've always wondered what's the plural of a mouse for a computer. I don't know if I feel comfortable calling them mice. And so what do we need to trial with our students? What do we need to consider? And what do they need based on their abilities and their needs to interact with the computer? What I love about the keyboards in my classroom, for the many years that I taught in public schools, I wrote grants. We'll talk about that in a little bit. And I used tons of different keyboards. And in fact, we got so used to, oh, it's John is on the computer now. I had 3 computer stations in my classroom. John's on the computer now. Let's go plug in. We know that John likes, and most of the time, if John was able to, he would go get the keyboard that he would need. Some of them have large keys. Some of them, the one that I love the most is there's an adapted keyboard that when you press the letter, it only types once, even if you press it. You know how on the typical keyboard you press and you get a whole line of M's? Not on this one. You press it, you can hold it from today till the next time we meet, and it will only give you 1 M. The next category of assistive technology that Guam system has are called daily living. And while I know, I've heard the lecture from my administrators, we are here to teach academics. However, our students still have to take their coats on and off. Our students still have to hopefully tie their shoes if they're able to. Our students still need to be as independent as possible when they're in the cafeteria and they're opening those milk cartons, or they're eating and not making a huge mess. And again, remember what I said, they need to be able to interact and access life in school the same as their peers without disabilities. And so daily living has to be considered when we look at AT for our students in schools. Environmental adaptations, there are lots of different ways that we can help adapt the environment to help our students be able to succeed using assistive technology. Certainly there are hearing devices that will help. It can either be something you wear that helps your voice be heard either to the whole class or solely to the one student with a hearing impairment, or it can be something the student uses to then be able to process information. And so there are lots of different hearing devices. There's mobility, they kind of lump them together, mobility, seating, and position. And this is where our therapists come in. This is where our physical therapists really need to consider attending this workshop, because you'll find out about different ways to use assistive technology devices to help our students be able to move around the classroom, to be seated comfortably, and then certainly once they're seated to be positioned. And I also want to invite our occupational therapists to attend, because after I graduated and I started working at Oklahoma State, I then worked with the AT Act program in Oklahoma, and we wrote a multi-year grant working with little ones in our child development lab. And we collaborated with an occupational therapist to help with positioning of a student so that then she was able to interact with her communication device. But it took not just the speech and language pathologist, but also the OT to help with that. We also have rec, sports, and leisure. And again, I know we're supposed to be teaching academics, but you know what? Part of school is recess and part of school is PE. And if your students have an intellectual disability, maybe you have Special Olympics that you do. And if you don't, hopefully maybe they'll be able to when they return to the mainland. And so we need to be looking at, again, how do our students fully participate in recess? We don't want them sitting on a bench and saying, I can't do that game because there are fabulous things. Just a quick view of one of them is, I love bocce, the Italian lawn bowling game. I don't know about you all, but whenever my prep period was always when I sent them to PE, I've never liked to sweat. But I love bocce because you don't really sweat. Bocce is not a real, almost everybody can do bocce. And the reason I say that is that we had tons of AT for bocce. We had a ramp that would roll the ball because it's Italian lawn bowling. And then two, your goal is to go after the Polino, which is a little ball that you toss out first. I had a student who was cortically blind, and we had a Polino that beeped, and she took first place. She took a blue ribbon in bocce. Lots of different opportunities for rec, sports, and leisure that we'll talk about more in the workshop.
We will return after this short break.
Language is the foundation for many types of learning. Language development is impacted if there is any loss in the ability to hear. Even a mild hearing loss can dramatically affect a child's language development. Early identification of hearing loss is key to providing appropriate intervention services to promote language development. For more information on the Newborn Hearing Screening Program, please call 735-2466.
We welcome back Dr. Gretchen Colade.
Certainly speech and communication. Okay, I'll share with you, that's my bias and that's kind of my wheelhouse. But to help students, nothing else counts as far as I'm concerned. All the other categories don't count if our kiddos can't communicate. And so tons and tons of ways, and I'll be happy to share with you all of them. My brother uses primarily speech and communication assistive tech devices. And then finally, vision. If you have a student with a vision impairment, lots of different ways that we can increase the font. We can do lots of different things to help our students visually, who are visually impaired, be able to interact with the materials that we put out. So those are all of the different features. And so hold on to those thoughts though, because we're going to go on. All right, so that's our first section. Second one will be for assistive technology for all students with disabilities. We'll be looking at the laws. I will say very truthfully right now to all of you, implementing assistive technology, considering assessing and implementing assistive technology in your classroom is not just a good idea. It is a good idea. Don't get me wrong. It's a great idea. It's also the law. We will review the 4 laws which impact assistive technology, and I'll go over them just real quickly with you to give you kind of a taste of what we'll do. I don't know if you've ever taken, one of those, been given a survey that said, if you could do it all over again, what would you be right now? And to be honest, I would be a special ed attorney is what I would be. I find the law fascinating, and I find that as a special educator or as an educator at large, if we don't know the laws, lots of people are going to be telling us things. And so it's so important to know what they are. So that way, when you have a conversation with someone, say an administrator, about the need for assistive technology in your classroom, and they say, nope, we're not going to do that, you can say, no, you know what? It's the law. So it's not just a good idea. Certainly the first law that we will go over is what's called the Assistive Technology Act. And that came from an act of 2004, and it's Public Law 108-364. And bottom line, it was written to include technology advances to improve the lives of all Americans with disabilities of all ages, in all environments, on a statewide basis by increased access to and acquisition of assistive technology. So every state and Guam, this is where your Guam system of AT comes in. must provide access to assistive technology. And like I said, not just the devices, but also the services, which is why I'm here with you today. And we'll spend time with you in April. A key thing, so that a key point of that one is that they provide services such as demonstrations, short-term loans, and other things that we'll go over more in detail whenever we meet. Now, so understand that there's an AT Act. So if you have families that are moving from Guam back to the United States, you need to let them know. Years ago, I was coming back from visiting my brother, and I met a young lady on the plane. She was probably 6 or 7. She used a wheelchair for mobility. And so I got to chatting with her because I actually had a foot injury at that time. So she and I were in the wheelchair line in the airport. That's a fun line to be in. You get to meet some really cool people. And so I got to, so I turned to her and I started to talk with her, and her mother jumped in to speak for her, including telling me what her name was. And, the professional in me had to say, has your daughter ever used an assistive tech device to be able to communicate? Because you could see she wanted to, and she was nonverbal. And so I hooked the mom up with the mom was actually from Virginia, the Virginia AT Act group, to be able to start to trial some devices with her daughter. The second law is the Individuals with Disabilities Education Act. And what we need to understand with that is that that considers AT needs of all students. And then we must document it in the IEP. We must document the development, the review, and the revision of the need for assistive technology. Schools are to provide, according to the IDEA, schools are to provide AT if it is needed for a free and appropriate public education. We'll talk about some lawsuits that have occurred. There was one that went to the Supreme Court in 2019. Did you hear me? 2019. And it affirmed the need for assistive technology. And so we'll talk more about that law and the law, and then also some court cases. I find that the court cases bring the stories of why it's important. And so I'll share with you the story of that one. A key part of the IDEA is that it can be at no cost to the parents. We'll talk about grant writing, and we can't delay. That's a huge issue, is we can't delay. We can't say we don't have it, maybe next year, okay? The third law is the Title II, and it is a civil rights law that schools are a government entity and therefore fall under the Americans with Disabilities Act. Now, a lot of this deals with structure, but and auxiliary aids and devices. But again, it very clearly says, the Americans with Disabilities Act says that students with disabilities must have communication that is as effective as others without disabilities. And then finally, I know I'm speaking to the choir if you're in special education, is the Section 504 of the Rehabilitation Act. And bottom line, that students may qualify for 504 without qualifying for special ed. And what we need to understand is that there's a reference to assistive technology that within the 504 Act that says special education and related aids and services, supplementary aids and services must be provided in the settings in which students are served. So huge issue with the law. So we will review them, we will understand the key points, and then we will talk about how to apply the laws to implement AT within your setting, your classroom, or your therapy session. So we'll cover that. Okay, now the next one is really the meat of what we'll do, although the others are meat too, so don't get me wrong. But this is where I get excited, because what I love about the sessions that I have developed with my work through Oklahoma's AT Act program is that we will look at identifying the sections of the IEP where assistive technology must be included. We will actually go through your IEP and we will find where it needs to be included in the overall objective statements. AT goals need to be there. Goals and objectives of the IEP need to be there. Okay, so let me back up. The overall objective statement for the child, you're going to talk about the need for assistive technology. Then you're going to write about the goals and objectives. You're going to list, we're going to implement this, and we're going to then we're going to talk in the objectives about where it's going to be located, where the AT device is going to be implemented, and then how we're going to evaluate it. And then finally, the third place that it's listed in the IEP is under the supplementary aids and services. So you see how with assistive technology, there are lots and lots of ways that we have to document. And if there's one thing we're good at in special education, it's documenting. And so we will then go on to examine documents to plan and implement an AT assessment. Now, let me also say, let me back up because I got so excited. But we will be doing, well, actually, and two here, I'll just include it here. With consideration and then with assessment, I'm going to give you so many different resources to help you be able to document, because that's the key with assistive technology, is that, well, with everything in special education, really with everything in education, is that we need to be able to document. Is there a need? And so now let's document how, and we will do that through several different documents. We will use what is called the SET by Joy Zavala. That is, it sets, again, we love acronyms, right? The SET stands for Student Environment Tasks and Tools. And that will help us start to filter down. Number one, do they need them? And then number two, what should we be looking at? We'll then look at the WADI. The WADI stands for the Wisconsin Assistive Technology Initiative. That's also an observation form. We will also look at what's called the Big East. And within the Big East, that's another form that is out there. I will not only tell you about them like I am now, we will spend time and go through them so that way you will leave our session ready to assess students. And this is one of the things that I, whenever I first started teaching these workshops in Oklahoma, I encountered educators who I think they thought I was going to say, I'll come in and help you do this. And my point to them and my point to you all is this, and this is why we're doing a series of these trainings, and I hope you can clear your calendar to attend, is that you all are the experts on your children. You're the one who, and in fact, if I were to say, I'm going to come in and tell you what to do, I'm going to come in and ask you have you ever tried and of course you're going to say, number one, I hope you're going to say, I have, and it didn't work. That's why I called you in. But I hope too that you realize that within you, you have the beginning knowledge that no outsider does to be able to examine and plan and implement assessments. And so I'm going to give you a lot of different ways to assess. What we need to understand with it is that assessment is cyclical. Okay, so it goes in a circle. And what that means is that we consider, we assess, we implement, we take data on it, and I'll give you lots of forms for that, and we'll go over lots of different resources for that. And then we evaluate and we say, and a perfect example was with the SET, the Student Environment Tasks and Tools. We had we started with a young man who was 4 in our child development lab. He went through pre-K and our kindergarten class in our lab school. Then when he transitioned to the public schools, the parents chose to keep him in kindergarten again. This was a young man with Down syndrome and intellectual disabilities. And so parents elected to keep him in kindergarten. Well, you know what? He was using an iPad with the LAMP app. Can't wait to tell you all about that when we talk about devices, and because he was so successful with it. But in the child development lab, he was using it in the ways that it worked there. Well, you know what? Then we had to reevaluate, because when he went to kindergarten in the public schools, they looked very different. And then we were very fortunate because we did pre-K, K, we did K again, and then it was a 4-year grant. We did first grade. boy, first grade was very different. So do you see where it had to be cyclical? All right. I will teach you all about how to do that, so that way when you leave the conference, you will feel very comfortable. And then our promises, and this is what I love about my invitation from the Guam system, is that I'll come back and I'll meet with you, so that then we can actually talk through, I did this, how did it work, what else could you do, let's think. And then we're going to be able to summarize the AT implementation process, just like I talked you through just now. All right. And this is kind of one of those. And not only that, but you also get, you will be given more detailed information on, again, how to write it in the, write assistive technology into the IEP. We will do goals and objectives. We will work on those together. And what I love about while I wish I could be there, I truly, truly wish I could be there. And in fact, let's hope after COVID gets kind of under control. I will tell you, I got my first COVID vaccine yesterday, and I'm feeling lousy. And so I'm so kind of upset because all my friends said, "Oh, I didn't have any reactions, and my arm hurts." But I'm so glad to get it, because you know what? It's one step closer to be able to come to Guam next year. That's what I'm hoping. But so we will actually write assistive technology into some IEPs. And what I love about the Zoom is that we can still facilitate that type of instruction through the chat rooms.
We will return after this short break.
They say there are two kinds of people in this world: those who find themselves and those who create themselves. Are you looking for purpose or deciding it for yourself? Will you plunge waiting for someone to catch you? Or will you jump and build your wings on the way down? Seek a path or carve a path. Wait for the future or build it. What is a school but a set of walls waiting for greatness? And who are you but someone destined to achieve it? Here, between the street and the jungle, against time and tide, we push and pull just like the currents. Our ocean of dreams will meet the odds ahead and rise above it all.
We welcome back Dr. Gretchen Colade.
All right, we're going to summarize the AT implementation process. We're going to compare and contrast assistive technology across disabilities. And I think this is where, you know, one of the key things is that we absolutely positively need to feature match. And I'll teach you how to feature match. And what that means is we're going to look at the different features of assistive technology. And let me kind of run down just a couple of these features. The first is portability or weight. We want our children to be able to be as independent as possible using these devices. So what that means is that we want them to be able to carry them. We want them to be mobile. If they're used in one classroom setting and then they go out to music, we want them to be able to take it to music, right? And so we'll look at that. Another feature of assistive technology is durability. Whew, that's a big one, especially if you have kids that are hard on things. I still joke that there is not an OtterBox out there in the world for some of my students. That doesn't mean we don't use them. It just means that we're ready for helping repair it. And we'll talk about the repair issue. Certainly, we want to look at text-to-speech devices or devices that offer text-to-speech. And what that means is that the device will read it to a student. That would be wonderful, wouldn't it, for a student with visual impairments. Also for students who have difficulty reading, but have no problem with comprehension once it's read to them. Word prediction is another feature of assistive technology, and that is where you start to type in the word and then it predicts it. We're all pretty familiar with that, although I think that we've all probably had those kind of jokes about, oh, what did it think I was going to say? Does it have an external or an on-screen keyboard? That's a feature that we need to consider whenever we're looking at a student with their abilities and needs. We want to look at dictation. Is the student able to dictate and then have it be written for them by the device, so that way it saves them time, it saves them energy. I had a student who just had a painful grip And we use dictation for him for his English classes, or his English class with me. And then certainly a feature is battery life. Boy, so you know what I love about doing any of these workshops is that I get to spend time with people who we all nod our head and say, regardless of their abilities or their needs, we share so much more than the things that make us different. And we have all experienced battery life issues. And so that's also, though, another feature that we compare and contrast with each of our students. And so one of the key things that we will spend time doing in the workshop is we will definitely spend time talking about some case studies, and then I'll have you all, it'll be interactive, I'll have you all, you know, certainly without breaking any confidentiality, give us some examples of students and their abilities and their challenges, so that way we can kind of factor down. And a perfect, you know, one of the things that I always say to my students, and I know you all have probably heard this before, is once you know one child with autism, you know one child with autism. The same can be said about everyone. Right? And so that's why we will look at different students with disability categories, but then we're going to factor down, you know, oh, they're a 15-year-old with muscular dystrophy, and now they have to write a 3-page report. What's the best way to do that? And so we will go through, I will teach you all how to consider, I will teach you all how to assess, I will teach you all how to feature match, and then how to evaluate the effectiveness of it. All right, and we will take it down to comparing and contrasting a student with a disability. And let me back up just for a sec about the implementation process. Another thing that we will take into account is what are called operational procedures. Every district should have a written operational procedure for assistive technology. That falls under the administrative support that I talked about with the quiet. And I'll tell you that, you know, when I teach the workshops here in Oklahoma, I don't get too many hands raised on the screen when I say, first I say, do you have one? And I give them the choice of yes, no, or I don't know. Tons of no's, but many more I don't know. And so I'm going to teach you all how to do an operational procedure, and it's not hard. And what it basically does is it sets up how we implement the assistive tech process. All right, so my promise to you is that you will leave this workshop with so many new resources that you can use for your students and in your program. Now, the final thing we will do is identifying funding resources for assistive technology acquisition. And a key thing with this is I wish we lived in a world where we didn't have to worry about funding. Wouldn't that be a great world to live in? It's not the world we live in. And so what I will share with you is, I'll share now with you that my first teaching experiences were overseas in Germany. My husband's retired Air Force. And when we were there, I got hired by, okay, it used to be called the Department of Defense Dependent Schools, and now it's Department of Defense Educational Agency, DODEA. I worked for DODEA. And so, man, I didn't have any problem getting any resources I needed, did I? I mean, I asked and I got. And so then I moved to Oklahoma, and I walked into a classroom that literally had one small box, like about the size of a shoebox, of connecting blocks. Okay, I taught art, math, and English to students with moderate to severe disabilities. And I had 17 students that first year, all on different levels. And all I had was a box of matching blocks. And I went to the school office and I said, hi, where's the supply? Hi, I'm Gretchen. I'm new. I'm so excited to be here. Can you point me in the direction of the supply room? And the secretary, who became one of my dearest friends after the 100 years that I feel like I worked there, she talked under her glasses and she looked at me and she said, you're not from around here, are you? And I learned that in Oklahoma, if I wanted good things in my classroom, I needed to write grants. In the 15 years that I taught for Enid Public Schools here in Oklahoma, I received over $50,000 in grants. most of them for assistive technology. And so I will share with you what I've learned about finding funding sources so that way you don't, remember how we backed up. First of all, it has to be offered at no cost to parents. And then secondly, there can be no delay in implementing them. So I'll help you. I'll help you figure out where the funding sources are. Now, I'll tell you, my challenge will be, between now and the time that we meet, sifting through all of the resources that I've used so that way I can be sure to give you ones that, being in Guam, you can use in Guam. And so I promise you, though, that it has been my professional experience that people want to write you a check when you promise to do good things for children. They do. And in fact, my class actually published 2 books. Whew, that's where I got a lot of my keyboards. We published 2 books about Enid, and in both cases I asked for local funding, and I had to turn money away or promise them that I would contact them on the next one. So when you hear it has to be provided at no cost and that there can be no delay, I want you to think, no worries, we're going to figure that out too. All right. So when are the upcoming webinars? They start on April 16th. Oh my gosh, a little over a month from now. I can't wait. We'll go from 9 till noon, and we will do consideration of assistive technology. That's all we're going to talk about, is how do you consider AT for your students with disabilities. And again, it's in all settings. All right. Then on April 23rd, we're going to go from 8:30 to 3. With a lunch break from 11:30 to 12:30. And so that will be gathering information and trailing devices in 2021. And that'll be a 6.5 hour. We'll do it though, ladies and gentlemen, we will, and we'll have a good time. And I promise I'll keep you on the edge of your seats so that way we'll be doing lots of interactions and lots of discussions. We then will do April 30th from 8:30 to 3 with, again, a lunch break from 11:30 to 12:30. And that one, we will do AT in the IEP and implementation. And again, it'll be a 6.5 hour session. Now, then this is where the follow-up comes. And I'm so excited about the follow-up. And boy, you need to thank the Guam system for AT for coming up for this one. And in fact, I've told Oklahoma, the AT Act in Oklahoma about it. And they love this idea. And in fact, I think I'll be doing it here too, is we will be doing a follow-up where I'll be available. You come back, because that's on May 7th. So that gives you some time between the time we start April 16th to May 7th to let's talk about things. Let's talk about how things are going and what have you been challenged with, but also what are your successes. Oh my gosh, I really like this particular form, because while I listed some of the resources that I'm going to give you, what's great about the process is you get to decide, I know this student has these abilities and these needs in this particular setting. Again, remember with the set, it's the setting, the environment, the student, the environment, the tasks, and the tools. All of those will change for each one, and you might choose to do a different form then, okay, based on the student's needs. So that's what we're going to do. Now, I'll also share with you, though, that on each one of these, the first 3, maybe even the 4th one, we'll see. I'll talk with Guam system about it. We're going to do what's called make and takes. I'm going to teach you how to use very simple items that hopefully you have around, and I'm going to run it by Guam system to make sure that you have access to them, to make low-tech assistive tech devices for your classroom. And so we're going to do that too at the end of each one of the sessions. So we're going to end on a really fun note, all right? Because we all love to learn new things that we can bring into our classrooms and to maybe even have our students help us with, all right? And so those will be the dates and the times. So now let's talk upcoming webinars. Yes, so here they are. Now let's talk about who should attend, the attendees. All right, with the attendees, here's who we suggest. So if you're listening to me right now and you fall into one of these categories, I hope that you will register. I'm going to give you information. Well, you'll have information to register. So who should register? Certainly the Guam Department of Education assistive tech personnel. I hope that you'll consider attending. I know that you know a lot about AT if you're part of that personnel. However, we can all learn something new. And then certainly any of the special ed personnel. And by that, we mean dropping down, we mean the special ed teachers. If you have paraprofessionals that you would like to clear to be able to come, that would be great too. Within the Guam Department of Education to have special ed administrators. We need you there. Please, please come. Certainly CRT and transition teachers. We're going to talk a lot about transition all through the sessions. Certainly the Guam Department of Education, I just already mentioned the special ed teachers, but boy, general ed or regular classroom teachers, we need you there. Because in 2021, our students with disabilities should be included in with their peers without disabilities classrooms. And so please consider within your schools trying to get, even if it's just one regular classroom teacher to attend from each school, that would be fabulous because then they'll come back. The Division of Vocational and Rehabilitation, I highly suggest that you try to clear your calendar if you work for the DVR. And the reason is this, realize that, remember how I talked about the AT Act of 2004? That, if you remember, I know it's been a while since I said it, but it is for all people of all ages. And so number one, with DVR, you're going to be working with our transition teachers. But then you'll learn about the access to assistive technology for when they leave the schools. All right, and so we will be able to give you help. Oh my gosh, the University of Guam Accommodations Office and Guam Community College Accommodations Office, please consider this a genuine and heartfelt invitation for you to come and spend time with us learning about assistive technology. Because while I realize that within our universities and our colleges that we can provide accommodations and not modifications, think about it. AT primarily provides accommodations. It provides access to the information. And I'll give you several case studies of successful people who have transitioned from school into either community colleges or into universities, being able to use their assistive technology in their new settings. And so lots of invitations out there for many of you to attend. And then if you're just interested in assistive technology, I welcome you to come as well. So that is, oh, and here's what you need to do. Okay, so attendees for the webinars must RSVP by March 29th. Registration's required, and that makes perfect sense, doesn't it? That you need to register to get to the to be able to then receive the materials that we're going to send out. You'll receive reminders every 2 days of the webinars. And so that way, in case it drops off your list or your phone crashes with your calendar, don't you hate that when that happens? I always have a backup. I'm too old school to not also have it on paper. You'll receive the webinar materials. I'm putting them together now and we'll be getting them to Guam System for AT. And the Make It Take It kits. By April 7th, we're putting those together as well. You'll receive the Zoom link and reminder by April 12th and 15th for April 16th. Again, you'll receive one on the 19th and 22nd for the 23rd, and then the 26th and 29th for April 30th. So we have lots and lots of good things coming up. I hope you will take the time to clear your calendar and make this a priority. Again, mainly because AT is not just a good idea, it's the law. We have to do this. And we need to have the information so that that way we can not only serve our students and serve them well, but to also be able to then share the knowledge. right? So that way you can take it back to your schools and share it with people. And then hopefully invite them to contact the Guam System for Assistive Technology in the future, so that way they too can be able to implement, consider, assess, implement. I got it. Consider, assess, implement, and then finally evaluate assistive technology for your students. So I look forward to spending time with you all and meeting you so that way we can actually chat. I hope all is well. Please stay safe, and I will see you in a little over a month. Take care, everyone.
Give us your thoughts on AT for all students with a disability.
Welcome. We are excited to tell you about the Cootie Loan Program. The Cootie Loan Program is an alternative financing program under the Guam System for Assistive Technology, or GCET. GCET serves all ages, disabilities, and in all environments of education, employment, and community living. GCET's mission is to enhance the independence, productivity, and quality of life for all Guam residents through increased access and acquisition of assistive technology, AT devices, and services. Did you know that GCET has helped over 150 Guamanians buy assistive technology and supplies to start their own business? What is assistive technology? Assistive technology is any item, piece of equipment, or product system, whether acquired commercially off the shelf, modified, or customized, that is used to increase, assist, maintain, or improve the functional capabilities of individuals with disabilities. Assistive technology service is any service that directly assists an individual with a disability in the selection, acquisition, or use of an AT device. The Cootie Loan Program has two initiatives: the Guam Options for Alternative Loans, Assistive Technology, Goal AT, and Get Guam Teleworking, GGT. The Go AT initiative is for the purchase of assistive technology devices and assistive technology services. The amount for loan requests can range from $500. What can you purchase through the Goal AT initiative? You can purchase accessible vans, mobility device, hearing aids, or home modifications. The second initiative, Get Guam Teleworking, GGT, provides low-interest loans to qualified applicants for the purchase of equipment, supplies, and services necessary to secure employment opportunities through our program. Teleworking through the Cootie Loan, you can purchase supplies and equipment to allow you to telework. The Cootie Loan offers a low interest rate and flexible repayment terms to fit your budget. To be eligible, you must meet the following requirements: be a resident of Guam, a person with a disability, legally able to enter into a contract, and provide assurance that the loan will be used to purchase an assistive technology device under the Guam Options for Alternative Loans, Assistive Technology, or to purchase equipment under GGT. Some of the required documents may include a valid photo ID, a letter of disability, price quotation from vendors, Bank of Guam certification and authorization form for credit check, verification of employment, business plan for GGT applicants, if employed, pay stubs from the last 3 months, if applicable, Social Security verification letter, if applicable, public assistance such as welfare, food stamps, public housing, verification letter, and if self-employed, GRTs for the last 3 to 12 months. GCED has partnered with 2 agencies, the Pacific Islands Microcredit Institute, who administers the loan, and the Bank of Guam as the lending institute. How do you apply? To know more about GCED and the Equity Loan Program, please visit our website at www.gcedcedders.org, or to schedule an appointment, contact us at 735-2490 or 2491. To visit our office, we are located at House 19, Dean Circle at the University of Guam, or you can email us at gsat@guamcedders.org. Thank you, and we look forward to meeting you soon.
This concludes our second installment of the 27th Annual GSAT Conference. We hope you enjoyed today's program. Join us for our final presentation tomorrow as we explore building bridges through assistive technology. Be safe and good night.